The case is now being recorded.
Good morning. Welcome to the Appeals Court. I am Justice Rubin. I'm joined today by my colleagues, Justice Milkey and Justice Henry. We will be hearing 3 arguments this afternoon by Zoom due to the ongoing pandemic. The first is number 20-1144. The rules for our video conference arguments are, of course, the same as our rules in the courtroom, which is to say 15 minutes per side and no rebuttal. And with that, we will hear first from Attorney Goldblatt.
Thank you, Justice Rubin. I'd like to start with the 3 facts that I'm concerned might be unclear after the Commonwealth filed their brief, and just to lock down what the record shows on that. The first one is that the defendant's trial attorney asked for 2 additional peremptory challenges before juror 93 was seated, several minutes. This matters, of course, because if she had asked only after, then she would have failed to preserve the objection to not having received the additional peremptory challenges. This is addressed extensively in the reply brief, but I want to draw the court's attention to it because it was misrepresented in the Commonwealth's brief, and I think it's important to nail that down. The second is that the alleged victim did, in a conversation with the police, identify Mr. Olbinski, who was one of the co-defendants, as the person who shot him. And the way he did that was he said, I recognize that person. That's the guy who said, you're going to die for money. And he had been very clear that when he was having the conversation with the person who eventually shot him, that person had said, you're going to die for money, and then shot him. So those events happened very close in time, and they were by the same person. And that another person, who I'm going to call the non-shooter, he's the other co-defendant who was there for all of this and who did not actually fire any weapon. The non-shooter said, I'm not going to kill someone for nothing, let's go. So there's very different conduct between the shooter and the non-shooter. That matters because Mr. Chamberlain is explaining to the court he was misidentified as the shooter and was in fact the non-shooter. And that this matters because the non-shooter clearly from that conversation never shared any intent to murder anybody. So that would matter for the assault to attempt to murder charge. And so the identity of the shooter is an important issue.
So I have a number of questions for you, Attorney Goldblatt. As usual, you've done a very thorough and interesting and comprehensive job for your client here. But I'm trying to sort out some of the ramifications of these arguments. I guess I'm very interested in this question of identification, but I want to start with the peremptory challenges and see if we can at least nail a little of that down. It seems to me that what happened here, I understand your argument about the error being preserved. There's no reason to ask for 2 additional challenges right when the very last person is being seated, unless you intend to use one of them. And the request does come at the point where the other side has said it would not challenge. And I will also add that several jurors before this, the prosecutor says, after the final challenge has been used up by the defense counsel with respect to the person seated number 13, the prosecutor says no challenge, and the defense counsel says, I have no more challenges, which is correct. Then more people are, the judge says, let's keep going. And now we've got more people coming in. And counsel does say this, shouldn't I get 2 more challenges? What I don't think happened here is I don't think 16 people were seated exactly. I think 14 were seated, but what happened was after voir dire and after the seating of jurors, the judge decided in one, maybe both cases for hardship, decided to remove 2 of the people who had been seated long after this was over with. Now, in fact, the judge actually did that with respect to one of the other jurors, Mr. Patricio. The judge actually did that as well earlier in the proceeding. But, and at that point he said, in fairness, I'm giving you another challenge. That's what he said to defense counsel. My question is this: do you have a case that says when that happens, and so the tactics and strategy of defense counsel and the use of peremptories may be undermined because not knowing this was going to happen, they used up their last challenge when they might otherwise not have, or whatever. Do you have a case that says they are entitled to additional challenges?
No, I could not find a case where this had happened. It's not the standard practice, is my understanding. I never certainly had it happen as a trial attorney, and it's not the standard practice for judges to wait until the jury is full, defense counsel has used up all their challenges, and then begin replacing jurors. That's very unusual. And there weren't cases that specifically addressed it that I was able to find.
So how do we decide whether this is a situation in which someone deserves another challenge or not?
I think this is an issue where the question is, did he get, so the court can ask itself, did Mr. Chamberlain get what the rules governing peremptory challenges in Massachusetts accord him? Did he get that? And I think there, and you'd have to just look at that question and argue it on the facts from first principles, because we know what the rules are, we know what he's supposed to get, and we know what happened. So when you look at that, is that what the rules contemplated? That you could, and remember that this would be sort of at the extreme end, fill up the jury. Defense counsel uses all their peremptories, 14 jurors are ready to go, they're about to be sworn, and the judge says, I'm changing this up. I'm going to strike all these jurors. These jurors should all go home. They seem exasperated. I think that's what he said about one of them. Seems exasperated. I don't want that on my jury. I'm going to pick these 14 people who seem not exasperated, and they're on the jury instead, and then turns to the attorney, which the judge did in this case, to defense counsel, and says, I don't want to hear from you about it. Would that have been okay? And I think, again, that clearly not, because that denies the defendant the right to consider and have the right to it effectively denies him of the right to use peremptory challenges. He can't use them to get people off the jury. So he has his jury selected without him being able to use these. So I think you start there and you say, clearly that's not okay.
Why does counsel not have to? Now, of course, what the judge said turned out to be untrue in the end. The judge said, oh, I'm not going to put this 16th one on. Don't worry about it. That's no problem at all. But if and then ultimately they decide, oh, let's get rid of Mr. Teixeira. And they do, and he does seat the 16th. Why doesn't the defense counsel at that point have to say, hey, Your Honor, you said you weren't gonna do this, but you are, and I asked for a peremptory because of it. And just like you did earlier, when you said in fairness, you'd give me an additional one, I need an additional one.
Well, I think that asking for an additional one is sufficient without saying, Judge, you're doing this wrong, or you did this before. I think starting out by saying, wait, let's go back. I should get an additional one. However, in this case, the court, right before, it would have been appropriate to remind the court, oh, you said this wasn't going to happen. I would like my additional challenge now. The court said, I don't want to hear from you. I don't want to hear anything from you. So at that point, it's arguably a contempt for
that's a little strong. I mean, I don't know the judge, so I can't say, but I would hope that wouldn't be a contempt.
We would all hope, but it certainly is not ideal. And having been told, I don't want to hear from you about this, I think they could ask, are you telling me that you are forbidding me from pointing out that? But you're now in a very, very difficult situation as a trial attorney. And I think once the judge has specifically said, I don't want to hear from you, and knowing that she'd raised it before, right? So the judge knows what he's saying he doesn't want to hear. I think that obviates any obligation on her part to raise it a second time, right? Yes, normally he says it's not going to happen, then he changes his mind, says it does. I think it would be best practice to raise it a second time, but I think it stops being best practice if the judge says, I don't want to hear you raise that a second time. So then it's no longer best practice. It's better to defer to the judge at that point.
And can I ask, and I don't want to take all your time up, can I ask you a question about this hypothesis that I don't fully agree with your characterization of what the victim Alberto says. He says the person running around upstairs came down and said this to him. This is in the 2010 interview. And it's true that on cross-examination, he might have been asked, wait, which of the people said this thing about the money, or did both of them, or what? It is not clear to me that it counts as an identification of Olinsky as the shooter, but there is this business of who's Jewish and who's not, and so on. And my question is this: in assessing prejudice, in order to argue that Olinsky was the shooter and he was the guy upstairs, he would have had to admitted guilt on 2 charges for which he was sentenced to something over 5 or 8 years each, right? He would have had to admitted, the assault he might have been acquitted of, but he'd have participated in the robbery, and I don't remember what the other 2 charges are that he's convicted of. What do we do about that?
Judge, he doesn't have to admit that he was the shooter, the non-shooter, in order to challenge his identification as the shooter. So he can certainly, as the trial is unfolding, that strategy or tactic might change. But whether it would have been helpful for him and his attorney to establish that whether he was there or not, he certainly wasn't the shooter, is a different issue. And there are 2 ways that he could have done that. One is by preventing testimony that he was the shooter, by litigating whether this was reliable. And as I've covered in the brief, there's a lot of evidence that these identifications, all of them, by Mr. Alberto, the alleged victim, were not reliable. And I won't go into that again because I see my time's running down. But that was a live issue that could have been litigated and was not. And I want to be clear that although his attorney did litigate the police conduct in repeatedly showing these photo arrays until they got their identification, and they had to go through 2 of them, of Mr. Chamberlain, there was never, and she did also challenge the identification of Mr. Chamberlain as Marco, whether he had made those calls, which I think that's a dead issue. He clearly made those calls. That I think there's so much evidence unrelated to identification that's a dead issue. But she never challenged whether Marco was the shooter or Peter was the shooter, Peter Chamberlain, whether that identification, saying this person walked into my house and that was Marco, I recognize his voice. So that was never challenged. And a lot about these identifications was very, very unreliable. For a lot of really good reasons. Mr. Alberto was in a terrible situation. There's a lot of research that people in that situation are not reliable in how they report identification. So
am I correct that a witness testified that the defendant said the Russian had done the shooting?
I'm sorry, I don't remember. And because that's self-serving, it wouldn't have been particularly important in this case.
No, but
yes.
I'm thinking about what the lawyer might have said or done. Can I ask you this? Mr. whatever his name is, Oshinsky?
I'm sorry, it's Olbinski, O-L-B, and then
Olbinski. Mr. Olbinski's name is not mentioned during the entire trial, is that right?
Mm-hmm.
Why?
This is not a question that I asked his attorney, and it's not in the record as to why it was never mentioned. I can say that his attorney said she never saw that video where Mr. Olbinski, where Mr. Alberto identifies Mr. Olbinski as the person who said, "You're going to die for money," and then bursts into tears. So
But I
the
don't
because she didn't see it-
understand, and I'm going to give you more time. I'm sorry, I've taken a lot of time, but I'm trying to sort through this. Mr. Olbinski pled guilty to this crime
Yes,
prior to trial,
yes.
but did not cooperate or testify.
I don't know. He
Oh,
didn't
he didn't
testify. I
testify.
don't know whether he ever agreed to cooperate.
And the defense counsel didn't say, there's a guy who's already pled guilty to this. That's the shooter. That, you know, this is just nonsense. There's nothing like that.
That is correct.
So the Commonwealth argues that because the defendant was a joint venture in the robbery, it doesn't matter who shot the victim. What do you say to that?
I say it's wrong as a matter of law because the joint venture, and I see my time has expired. Shall I go on?
Yeah, you can answer, of course.
Thank you. So the joint venture would have to share the intent of all elements of the crime. This is different than a felony murder theory, right? Like, I think the Commonwealth is a little bit conflating felony murder here. This was not charged as a felony assault with intent to murder. It was charged as a joint venture, would be the theory. And there's no evidence that the non-shooter had any intent to murder. The intent to murder was based on the fact that the shooter said, I'm going to kill you. And there's no evidence that that was part of this plan, which appeared to be to go in, push into the house and get into this safe. And in fact, the non-shooter specifically said, I'm not going to shoot anyone over nothing. Let's go. And then sort of hustled the shooter out of the building once the shooter sort of went berserkers, to use the technical term. So there's a very different treatment of the shooter and non-shooter in terms of intent with respect to ending a human life. And that matters hugely if you're going to argue that they shared an intent to murder Mr. Alberto. So I think that's just incorrect as a matter of law because of what the standard is for proving a joint venture. They don't have to have a meeting of the minds, but they have to he has to at least have the requisite intent.
I take it the statement given by Mr. Alberto to the police included the reference to Jewishness?
Mr. Alberto's, that recording,
Not the
recording.
recording of the 2010. I'm talking about during the trial, when Alberto is testifying, Alberto says, and then they said they were going to get my wife. And defense counsel says, I object. I've never heard of this. This is a total surprise to me. It wasn't in the statement that he gave to the police. And the prosecutor says, it's a surprise to me too. And the judge says, this doesn't look intentional to me. And they never mention it again. But when they get to the part about Jewish, counsel doesn't say, I never heard that before. So counsel obviously had heard something Alberto had said before, presumably through discovery. Of course, it would be mandatory discovery if they had interviewed Alberto. Do we know the contents of that?
No, that's not in the record. That's not in the record for trial. I didn't put it. I don't have. It's not in the record appendix. It's nowhere.
But don't we have to know that they were surprised by the Jewish comment before looking into Oblinsky's ethnic background would have been something that they shouldn't have already done?
I have nothing to offer on that. The attorney didn't announce that she was surprised, but I also think many things happen in trial that aren't necessarily in any pretrial report. But if they're not prejudicial, there'd be no particular reason to mention them or to interrupt a proceeding.
No, I agree
It's not
with
in
that,
the
but
record.
I'm saying for a new trial motion, I would want to know, I think, that they weren't told in discovery. The shooter said Jewish. If you were told that in discovery and you have this guy Oblinsky, you might look into it.
I would argue that wouldn't be our burden to come forward with. If the Commonwealth had provided that information in advance, I think it would be up to the Commonwealth at that point to say, this information is new, that he's Jewish, but they should have investigated it because of this.
Well,
we don't have to come. Do you see what I mean? Like, if it was supposed to have been investigated, then they would have come forward with, we provided this in mandatory discovery, and therefore they should have investigated it. I think that's too high a bar for Rule 30 to go through and make sure that it wasn't anywhere before. when the issue of is it newly discovered, the fact is newly discovered.
No,
And then
no,
if the
but
Commonwealth
counsel-
wants to argue that,
Counsel, just to be precise, I thought your argument was that the new evidence was learning that Obinsky was Jewish.
yes, that's the new evidence.
Which is very different from never having heard the comment, I'm Jewish. I thought that was understood by all, that everyone was aware of that.
Yes, that happened in trial. It was public. He said, the guy said, I'm Jewish. I don't care about your prayers, I'm Jewish. But Mr. Chamberlain couldn't do anything with that fact because he didn't know that anyone was Jewish.
Oh, he
Didn't
knew,
that put him-
but he knew he wasn't Jewish.
Yes,
And he didn't say, I don't know who this guy was who said this thing, but I've never told someone I'm Jewish. I'm not.
he also never shot anybody, but whether he goes on the stand to talk about all the ways that this testimony is wrong is a tactical decision with a lot of implications going beyond proving Judaism at that point.
No,
So
but couldn't he have proven it by some other means?
proven that he himself was not Jewish at that moment?
Yes.
I don't know.
Well, of course he could. Bring in his baptism record, introduce that.
I guess in the middle of trial, figuring out how to get the baptism record and then
Well,
bringing it in.
If they hadn't told him the Jewish thing before.
Yes, but we don't know if they did. I don't have that, and it's not in the record.
Isn't it your burden on a motion for new trial?
No, I would argue that it is not here because the fact that there was nothing he could do with this information is enough. If the Commonwealth had provided something to trial counsel and she didn't have it, or she didn't, like whatever had happened, if there was some reason that they should have known this in advance, I think it's on the Commonwealth at that point to come forward and say, yes, that's new evidence that they could have used at trial, but here's all the reasons they already knew it. I would argue that that's the Commonwealth's burden to disprove, to come forward with some evidence to show that what appears in the record, which is that here's a fact that just happens at trial and he couldn't do anything with it because he didn't know that Obinsky was Jewish. I think at that point, it's the Commonwealth's burden. So I would answer just a clear no. That's not his burden at that point.
We've kept you long. We'll give you A.D.A. Nadeau additional time if you need it in light of the time that we've given. Counsel, thank you very much, Attorney Goldblatt, and we'll hear from you, Attorney Nadeau.
Thank you. Good afternoon. May it please the court. I am Stephen Nadeau on behalf of the Commonwealth. Beginning with the empanelment issue, the judge in this case seated 14 jurors. 14 jurors were sworn, 14 jurors sat for the case, and as the rule provided, both parties received 14 peremptory challenges, although during the course of empanelment, obviously at one point the judge did provide an extra one to defense counsel. But nonetheless, the parties received certainly what they were afforded by the rule. To the extent that Judge Kane's kind of explanation may have been confusing at one point, defense counsel did attempt to clarify. She said, if we're going to go to 16, I think I should get 2 more peremptories. At that point, the judge explained his intention and counsel seemed to accept that and certainly at no point made an objection.
So, but what do we do with her argument that this was an unusual procedure where you think as defense counsel, you know who you're getting in the jury, and then suddenly the judge starts letting people go? You've made, your choices, and now but more people are going.
Well, first I would suggest that there's no indication on this record that, counsel have been keeping her gunpowder dry as regards to any challenges.
Wait. I don't know what that means. You know how many seats are left. You know how many people are coming up. And the way she did it, she left herself without a challenge for only 1 seat, right? Now, I don't know if that was intentional or not, but that seems like pretty good lawyering to me.
Yes.
You have 1 seat left and now you don't have any challenges, and that's a bummer. but you only have one seat left. But it turned out she had 3 seats left. And she said, when the final one came up, can I have 2 more challenges? And as your sister notes, presumably that's not because she wanted to have them in her pocket to tell the client about, it's because she wanted to challenge this last person. So she has to use, she has no challenges left. She thought for 1, turns out it's 3. Why shouldn't she get more challenges if she asks for them?
Because the rule requires that she have 14. She had 14. And to the extent that any of that
Can the judge seat 14 people, let her use up all her peremptories, then strike them all, move them all out? You know, they all have hardship. Let's start again. And now it's an empty box and she has no peremptories. Is that okay?
That would be a highly irregular scenario.
I agree.
But I think, again, I think the statute that was in effect at the time.
Oh, wait, you're saying that would be okay?
It doesn't feel.
That doesn't feel okay.
But I also imagine that kind of, extreme action would draw an objection and a spirit objection from counsel. There was no objection.
Except in that movie, the one with Tom Cruise, spirited objections are no stronger than regular objections, I don't think.
Sure, but here
strenuous objections.
But there was no objection, spirited or otherwise, or strenuous or otherwise, in this case. Rather, counsel may have raised it at one point. The judge sort of explained his intent not to expand the jury to 16 jurors, but to deal with a couple of scheduling issues. But certainly, counsel never urged on a for-cause exclusion or a specific objection to this issue. And so I would suggest then that even to the extent that this here constitutes an irregularity, that falls within Chapter 234, Section 32, which was in effect at that time, which said that any irregularity in the impanelment of jurors won't set aside the verdict unless there's an objection, which there wasn't, or some indication of prejudice. And there's no indication of prejudice on that ground here.
Did Alberto say in a pretrial statement to the police that the shooter had said he was unmoved by the prayers because he's Jewish?
I believe that did come out in pretrial.
In a pretrial statement. So you're saying that information was delivered to the defendant in Brady required discovery?
That is my recollection of the record. I am.
Where would I look to see that?
Well, I don't know. I mean, the discovery materials aren't necessarily part of the record here, but there was no objection. I don't think on that point
that's not my question. I'm trying to figure out whether due diligence would have revealed that this guy might be Jewish or was Jewish or half Jewish or whatever he is. But due diligence requires being on notice that there's some reason to look into it. And if they never heard about the Jewish thing until trial, then they had no reason to look into it. And if they did, then maybe they did.
Well, I can't speak to why it wasn't looked into, but and
you don't argue in your brief that they knew and should have looked into it. I was surprised to not find that argument.
I think I don't think Olbinski's religious affiliation was known to us. It's not, in
That's not what I asked you. I asked you whether the relevance of his religious affiliation might have been something that they knew about, so that they should have looked into whether maybe he was Jewish. The shooter's a Jewish guy. If only we had a Jewish guy involved in this crime, but all we've got is Olbinski.
Well,
but if they knew, right?
Well, I mean, this was also a situation where the shooter identified himself as Marco in the lead up to it. That wasn't true.
I couldn't agree more that there might be conflicting evidence about who the shooter is. And it might undermine Alberto or it might not. I haven't figured out how we do this prejudice analysis. I'm just trying to figure out, should they have looked into this before, or is the first they heard of this at trial? So looking into it afterwards is not too late. Even with due diligence, they wouldn't have known to look into it.
Again, to the extent that the defendant as the shooter was, part of the case was that he was making false statements to kind of set up this robbery, identifying himself as Marco. This kind of one statement in response to Mr. Alberto's prayers may have just seemed kind of par for the course, just one of those things.
Surely the judge is incorrect that no one would ever tell their true religion during a robbery.
Whether I don't know if ever,
that has to be wrong, right?
I'm sorry?
That has to be wrong, right?
I don't know that it has to be. It seems odd that someone would all of a sudden decide to be honest in carrying out the robbery about identifying themselves while wearing a mask.
Criminals are incredibly brilliant. They don't make mistakes at all. And sitting and while someone's praying to Jesus saying, that doesn't move me because I'm Jewish, you can't imagine some idiot robber saying that, because I see cases like that all day long. That's how they get caught.
Sure, it's possible, but I don't think, again, given the efforts to kind of conceal an identity, to with the mask, with the fake name, with all of that, I don't think there's any reason to believe that all of a sudden on the scene wearing a mask, he decides to be honest about that sort of thing.
Let me also say, lying about being a Jew may happen from time to time. I don't see much of that.
Again, I can't speak to what was going on in the defendant's mind.
Or whoever said that, yes.
But the key fact is that Mr. Alberto identified the defendant as a shooter, not based on any expression of religion or religious identification, but initially based on the facial identification, based on what he was able to see while
under
he was
a mask. I have a little bit of experience actually of looking at people with masks lately. I don't know if you do.
Yeah.
I think it's harder to identify people when they're wearing them.
Yes, and of course, but that is sort of kind of fodder for cross-examination to draw out the factors that might make such an identification unreliable.
No, I agree with that, but I'm just saying, the voice identification seems very strong, although your sister points out the problems with that. I just think it seems like an obvious thing to cross-examine with, right? There's another guy who's pled guilty to the crime who is Jewish, and the shooter said he was Jewish. That seems, I'm not saying that wins you the case, because of course, maybe that puts you upstairs looking for the money, and maybe that's no good. I don't know. But the failure to do that if you knew seems, I don't know what to say about that. And if you didn't know, then going and finding out, maybe it is newly discovered evidence.
Again, I'm not sure how it qualifies as newly discovered. Presumably, Mr. Olbinski, would have.
But why would you have looked into it if you never heard that the shooter said he was Jewish? It would be a wholly extraneous detail.
Again, I think for the very reason you said, the defendant knows he wasn't Jewish. If
he knew, I just keep coming back to the same thing, which is, were they told in discovery that he said he was Jewish? Now, it may be your sister's burden to show, but you haven't argued otherwise.
Can I just point out that I'm looking at the motion. There's no allegation that they weren't aware that the statement was made. The basis of the motion is that the defendant has since learned that his co-defendant was Jewish.
Yes, and so my understanding is that this was part of the statement provided. without an allegation from counsel to the contrary, I don't think the defendant has made any burden on this point. And again, based on all the evidence tying the defendant, whether through the identification, through his phone number, his records going back to him, the email address going back to him, his MapQuest search, all of these things suggest that an errant comment through this course of events that someone was Jewish was not going to be worth much time and effort.
Well, I don't think it was an errant comment. I think it seems like it was meant to convey your prayers to Jesus Christ are not going to move me because I don't believe in that God, that it was in fact a significant intentional statement. But I don't know that it matters what your religion is to say that to get the person to give you the combination to the safe. Anyone could have said that regardless of their religion.
Right.
Missing
And I think again, I can't look into the defendant's mind to know why he said it at that time. But it was certainly part of the course of trying to intimidate Mr. Alberto.
So just switching gears though, she argues you're entirely wrong about this joint venture concept, that that the case wasn't tried that way and it wouldn't satisfy the standard. What do you say to that?
Well, I did drop in a footnote. The judge instructed the jury regarding joint venture. The evidence here did show that the other two gentlemen were part and parcel of this entire course of events. They were there while Mr. Alberto was held at gunpoint. They participated in the burning of his hands, the binding of him, and there was no attempt to withdraw.
What is your best evidence of their intent to kill, of the non-shooter's intent to kill Mr. Alberto?
I think that it's that course of conduct, and then after the shooting, there's no evidence of withdrawal at any point. Indeed, I think the only comment after the fact is when the shooter says to the other person, plug him a couple more times. There's no sort of, oh, this went too far, I'm out. He just says, we need to go, which is sort of consistent with what they've been saying throughout, that this is taking too long. We need to get out of here even prior to the shooting itself. But so the evidence here did support a joint venture as to all three of these individuals. But critically, there was strong evidence based on visual identification, voice identification, as well as some of the other phone records and other things identify this defendant specifically as the shooter. There was a strong case on that point, I would suggest, as to him being the principal, but even if not, there was also sufficient evidence as to the joint venture. I see my time's running out, unless the panel has any other questions.
Of course, we did question your sister for some minutes after. If you have anything further you want to add, of course we have your brief and your argument.
Yes. I don't think so. I think we more or less addressed each of the subjects. Thank you for the time.
Excellent arguments by both of you. Thank you so much.
The case is now being recorded.
Good afternoon. Welcome to the Appeals Court. I am Justice Rubin. I'm joined today by Justices Milkey and Henry. We are hearing argument by video conference due to the ongoing pandemic. The rules for argument are the same here as they are in our courtroom, which is to say 15 minutes per side with no rebuttal. The next case we are hearing is number 20-278, Commonwealth versus Ney. I will remind counsel that it is a partially impounded case and not to refer to impounded information. And we will hear first from Attorney Kelly.
Good afternoon, Your Honors. If it please the court, my name is Brian Kelly and I'm representing the defendant Roger Ney. This is an appeal from a denial of a motion for new trial, actually a withdrawal of a plea. I would like to acknowledge a couple of things. There were a couple of other arguments that were brought forward in the motion for new trial regarding a case of Manning Gonzalez Lopez. That is not brought forward and that's basically waived for the appeal, as is there was an issue of the defendant being on medication. That is waived. The only issue before this court is that we're arguing ineffective assistance of trial counsel regarding inadequate advice regarding pleading guilty.
But are you pressing the motion to withdraw the guilty pleas to the bombing or just to the murder?
Only to the murder, Your Honor. He served his time on that, and essentially, and it's not even that it's a moot point. There really was no question as far as what was happening on that. There were two different instances, two different dates, and the only one that is really called into question is the murder case, Your Honor. Your Honor, this is a unique situation. I've done these before, and a lot of times it's just a credibility contest between trial counsel and the defendant as to what the counsel told the defendant. In this case, we have a couple of matters that make it a little unique. I'm sorry, Your Honor, I'm looking around to see if I have a clock here to tell me what I'm at the time. Oh, I see it.
Yes.
Sorry, Your Honor. First off, this Attorney Brown, who was the plea counsel, took the case over after Attorney Schubert withdrew on it on the day of the initial trial. And at the time of the initial trial, Mr. Ney, the defendant, was ready to go to trial, and then Mr. Schubert exited and Mr. Brown took over. There seems to be a line of demarcation between where Mr. Ney was going to go with this case, taking it to trial, and then going ahead and pleading out. And I will assert to the court that the line of demarcation was exactly when Mr. Brown took over the case. And a couple of things that I would like to call the court's attention to, in that in the plea hearing, both prosecutor and defense counsel were commenting to the judge about the resolution of this case. The prosecutor told the judge that it was the defendant's position, at least since I've spoken with Mr. Brown, that he wished to resolve the matter. And it also commented that it had taken a while to do that. Mr. Brown thereafter got up and suggested, during my representation, the defendant wanted to take responsibility. I don't know what happened prior to it. However, call the court's attention to the evidentiary hearing, when on direct examination by the DA, Mr. Brown was asked, how did the defendant react with the Commonwealth's offer? And Mr. Brown's answer was, well, he ultimately accepted. I would assert to the court that does not sound like someone who wanted to plead out to this case from day one, as soon as his successor.
Counsel, we have a letter in evidence in which your client said in writing, I really want to plea. I'm paraphrasing. Why doesn't that end the discussion?
Well, I would tell you, if memory serves me correct, I don't think there was a date on that. And I completely acknowledge that, Your Honor, that you were correct. There's a letter that, and as did Mr. Ney acknowledge that. But the point that I'm trying to make here, Your Honor, is that the narrative that we got from Mr. Brown was that from day one, Mr. Ney wanted to plead out, which was basically the day he was ready to go to trial. And I would assert that the letter, and of course, you're absolutely right, the letter says what it says. I don't know how far along the process that was, and how long it was that, that Mr. Ney changed his mind. And I suggest that he changed his mind based on the fact that he was not properly advised.
So,
by
but
his-
counsel, one thing I don't understand about that argument of yours is that it seemed like in your briefing that you admit that the first attorney, the attorney who withdrew, went over all the weaknesses in the case with your client.
That, I believe, Your Honor, that he basically, Mr. Schubert, basically did suggest that he went over all the weaknesses.
So why did
but-
that just go away?
Well, because it's unclear from the testimony, other than the ambiguous, I went over all the testimony, there was nothing that said exactly what he went over. At the evidentiary hearing, and there was questioning by both sides of Mr. Brown as to what the weaknesses of the case. They were specifically spelled out in the case. There were actually 9 weaknesses that he put forward. And when questioned on both direct and cross-examination as to whether Mr. Brown went over those and explained them and discussed them at length with the defendant, his answer was primarily, I don't really have an exact recall, but it was in discovery. And again, this kind of goes, I believe, to your point, Your Honor, is that there was discovery out there, but the default answer kept coming up as, well, it's in discovery, it's in discovery. And I would suggest to the court that in following the testimony of Mr. Brown at the evidentiary hearing, when he acknowledged that the defendant told Mr. Brown that the first attorney had given him a copy of the discovery, but that he had turned it back to him. So at the time that Mr. Brown took over the case, it would have been a memory, of course, to the defendant, but he didn't have it with him. And at no time does Mr. Brown acknowledge that I gave him a copy of the discovery. We went over the copy of the discovery. He just keeps saying, and as a matter of fact, if I quote again from the evidentiary hearing, it seemed as though the defendant had read it, is what his answer was.
But counsel, Judge Henry's point is that you admit that Mr. Schubert, or Schubert, however you want to pronounce it,
Sure, yeah.
went over all the weaknesses in the Commonwealth's proof in detail with your client. If that's the case, why doesn't that again end it? Your client.
Thank you, Your Honor. There's nothing that says what the detail is. What was told is specifically in the testimony was that he went over the fact that there was no forensic evidence that could link the defendant to the crime scene, or they could link any evidence back to his home. That was the only thing that was specifically brought out. But there were some very telling weaknesses, Your Honor, that were discussed by Attorney Brown, such as the fact that there were 3 or 4 third-party culprits that wanted to harm the victim because of certain things that he was doing. That the victim had been beaten severely by 3 men in his home. Okay, and the fact that the victim had given his aunt a piece of paper with a telephone number on it, instructing her that if anything happens to me, take this to the police. And that number was not Mr. Ney. Those were never discussed specifically. Your Honor,
Counsel, I mean, the judge here on your motion said Brown reviewed all of the discovery with the defendant on multiple occasions. Are you challenging that finding of fact?
Yes, Your Honor, because the specific questioning that went on the second day of the evidentiary hearing by both the district attorney and defense counsel, the answers that were given back by Mr. Brown as to, did you go over this? Would you consider that a weakness? If so, what did you discuss with Mr. Ney? And the answers were, weak at best. Basically, the only, in fact, on redirect, the prosecution asked him, well, was it all in the discovery? And it seemed to be the default. It's all in the discovery. And yet we have testimony that there's nothing that did he have the discovery at some point in time? He did. Is there any evidence that Mr. Brown actually went back over all that discovery and can tell us as to what, if anything, he had to say? All the answers were, I must have, I should, I'm sure I did, or the like. I'm paraphrasing, Your Honor. I'm not telling you the exact word.
Counsel, why at that point in time, why wasn't this your client's burden to prove and not the Commonwealth's, given that your client is trying to withdraw the plea agreement? So in terms of what was produced in discovery and when it was seen by your client and all that stuff.
Well, Your Honor, I would suggest that the questioning of Mr. Brown at the evidentiary hearing on day 2, basically there was not much more that could be asked of Mr. Brown. They asked him, did you do that? And basically he said, I don't have a recollection of doing that. Did you discuss this with Mr. Brown, with Mr. Ney? I don't have a recollection of doing that, but it's in the discovery. And yet at the same time, he tells us that that he, and I would suggest this is what this means, that he, Mr. Brown, did not give him another copy of the discovery because his answer is, it seems like he read it.
But counsel, isn't part of the problem that there was 6 or so years between the plea and the motion? So the fact that counsel couldn't recall a specific recollection of what he had said is completely understandable.
A valid point, Your Honor. But I would suggest that, again, if you're going to default, if counsel was going to default back to it's in discovery, and then can't tell us that I actually gave him discovery, I mean, that certainly would have been the answer that would have put this whole case to bed. I think if counsel had said, it was in discovery, I brought it out and we went over it, that's certainly something that I would suggest he would remember, but that's not what happened. And I would ask the court to take note that in the plea hearing, after, and this all happens after Mr. Ney pleads, Mr. Brown gets up and basically says, and he kind of equivocates. He says, as defense attorney, this is somewhat of an intellectual challenge. And then he starts to list at least the first 3 of what I call the weaknesses, being the fact that the witnesses were the witnesses claim that Mr. Ney, in the same statement when he claimed he admitted something, he also denies it, and that there was no forensic evidence involved there. And then Mr. Brown goes on to say, and the other part of the case I found a challenge, and it doesn't happen very often. And he talks about the 3 people that wanted to harm the victim, the 3 people that beat him up, the victim giving his telephone number to someone else, and the identification. So I would suggest that that I'm not so sure that the way it was presented was that even Mr. Brown, well, Attorney Brown, sorry, was totally on board with the plea. There was a lot of there. In fact, even to the extent that when asked, did you look into, and I know we're not going into the meds, but did you ask about his medical condition and would that affect him being able to talk, which was about the first question that Judge Sweeney asked at the hearing. His answer was, I did nothing to find that out. So it seems like the juxtaposition of how adamant they were about going forward to it versus afterwards, I would suggest to the court backs up that this was not well advised, and certainly not as well advised as the statement that Mr. Brown made to the court when he listed off those 9 deficiencies, if you will. If the court,
Okay. I'm sorry, your time's
that's
expired.
fine, my time's up. I will rest on the brief and if there's no further questions.
Are there further questions? No, no. All right, very good.
Thank you, Your Honors.
We will hear now from you, Attorney Baker.
Good afternoon, Assistant District Attorney Lee Baker on behalf of the Commonwealth. So to begin with, I would have to respectfully disagree with my brother as to his characterization of Mr. Brown's testimony at the hearing. And in support of that, I would cite to the transcript of October 16th, beginning at the bottom of page 8 and going into page 9 is where Mr. Brown was questioned about the supposed deficiencies in the Commonwealth's case and whether he had discussed them. Now, my brother has said that Mr. Brown was pretty equivocal on that, and I'd have to strongly disagree with that. If you look at it, beginning at the bottom of page 8, he's asked, did you discuss the possibility of a third-party culprit defense? He answers simply, unequivocally, yes. He's then asked if he, before the plea hearing, did he inform him that some of the witnesses to his admissions would have said that in the same conversations that he also denied it. That's the only time that there's any hint of equivocation where he does say, I don't recall having an exact conversation like that, but it is contained in the discovery. Every other question following that is answered unequivocally that yes, he did discuss the matter and it's in the discovery.
Counsel, at this point,
Yes.
our interpretation of whether or not the answers were equivocal would
Yes.
seem to be beside the point. The question is, the judge made specific findings, and the question is, are those findings clearly erroneous or not?
Right, and what's interesting about it is that, so with the judge, regard to the judge's findings of fact, then of course, as you stated, it's whether they're clearly erroneous, and if they're supported in the record, say by the testimony, then they're not. But it's a mixed question of whether or not the finding of facts have a basis in the record and a credibility determination, because ultimately the judge in her findings credited the testimony of Attorney Brown and completely discredited the testimony of the defendant. Furthermore, there's also the issue, as I think Justice Henry was sort of getting to earlier, that there's a little bit of a logical inconsistency here, and that Attorney Schubert testified very consistently that he went over the discovery exhaustively with the defendant. And that would include the lack of forensic evidence, that would include the possible third-party culprits, that would include this note with a phone number that wasn't the defendant's phone number. All of that was exhaustively, according to Mr. Schubert, gone over with by the defendant. And if that's true, then that makes sense why the defendant would have, during the time that he was represented by Mr. Schubert, have felt confident in Mr. Schubert's assessment of the case that it was a triable case. Because it appears from the record, from what Mr. Schubert said, from the judge's findings, that Mr. Schubert's theory as to why it was a triable case was that he felt that on cross-examination of Melissa Taylor, who was the girlfriend of the defendant, that he would be able to conduct a good destructive cross of her that would take away her credibility as to the defendant's admissions. Furthermore, I think it is worth noting that these supposed deficiencies in the Commonwealth's case, while certainly they are arguably deficiencies, are not so strong as they might seem at first blush.
Counsel, can I just, before we get into any specifics,
Sure.
What makes the plea hearing somewhat unusual, at least from what I've seen, is, after laying out the facts of the case to support the conviction, the prosecutor starts pointing out the holes and problems in the Commonwealth's case.
Right.
What was going on with that? Is it
Sure.
the prosecutor was
Yeah.
scared of explaining to Judge Sweeney why they were not sticking with the murder one, or what's going on?
Well, that's my assessment of it based on my own trial practice, based on my discussion with the prosecutor. Here you have a case where you have admissions, right, by the defendant to having perpetrated the murder. Not only just admissions that he had killed the man, but admissions that explained his motives, that he was angry with the victim because he had beaten his cousin so severely that he was placed in a coma for months, and in fact had significant brain damage as a result. So all of these, the Commonwealth, had it proceeded to trial, certainly could have secured a conviction for first-degree murder. So the Commonwealth was making a significant charge concession, and of course the judge could have rejected that plea and could have not gone along with it. So I don't think that it's all that unusual that the prosecutor and the defense attorney, having worked out a plea agreement that was agreeable to the Commonwealth, agreeable to the defendant, would want to put before the judge some explanation for, well, this is why we're not going ahead and pursuing first-degree murder, and while we're making this charge concession. And
So that's why you think that that Attorney Brown also did the same thing?
Exactly.
Because I mean, the defendant argues it's a bit inexplicable why counsel would go into detail about the lack of evidence.
Right, and all I can say is that based on my own experience as a trial attorney, I was a public defender for years, then a trial prosecutor, having worked both sides of that equation and understanding how that process works, it frankly did not strike me as all that unusual.
Well, let me, given your unique experience, let me ask you a follow-up question, which is, say hypothetically, we were to live in a state where the parole board almost never granted parole to a second-degree murderer.
Right.
With that assumption in place, what exactly did the defendant get out of this plea bargain?
Right. Well, of course, that's something that can change with the political winds, particularly when one is serving a very lengthy sentence, and simply having the possibility that at some point you might be able to be paroled would, I would think, make serving a life sentence somewhat better than serving it without any possibility of parole. So ultimately, I would suggest that, what I started to say earlier, just to cycle back on that a little bit, is that some of these deficiencies in the Commonwealth's case would have been easily explainable at trial. One of the big ones is a lack of forensic evidence. Well, the victim had a roommate, Mr. Joseph Moody, who was present in the apartment, was in the bathroom when the murder occurred. He said that when he came out of the bathroom after hearing the thump, there was a large pool of blood in the apartment, and his dog was licking up the pool of blood. And so he got a mop and he mopped it all up. So the roommate cleaned the apartment, the crime scene.
Yeah, I mean, that doesn't eliminate all forensic evidence.
Well,
and some of the others are harder to explain. The eyewitness identification of someone else and the giving the phone number. If anything happens to me, it's this person, not the defendant.
Right.
Those are unusual
and I could see,
and valuable, I would think, for a defendant.
Sure, they certainly would be. I can speak to those. As far as the identification, now the identification was made by the neighbor across the hall, and what they testified to was that they heard noises, then they saw somebody pass by in the hallway with a sheath on their belt, and they identified that individual as someone other than the defendant, despite the defendant's photograph having been in the photo array.
You
Now-
don't see that, you don't see that too much.
Right, but now what takes a little bit of the power away from that is that witness is just seeing that one individual. That doesn't preclude that immediately in front of that individual was Mr. Ney.
Well, that's why you have a trial.
Exactly. And so of course, a triable case, no doubt, but
In
a
yes.
slam dunk for the defense where it would be
No.
completely
But
unreasonable to plead to it.
as Judge Milkey says, the plea didn't get him all that much.
Sure.
Right?
Yep.
So I don't know.
Well,
I mean, that's not the whole question, obviously, but it's
right.
it is something. Does anyone know whose phone number he gave to his aunt?
No, I don't.
I think we know there were 3 or 4 people who wanted to kill him.
That's exactly what I was going to say. It may have been one of the other people standing in line.
Okay, but that person may also have killed him. So, right.
A question for the jury. So, ultimately, my position is that the judge made certain credibility determinations here. Most importantly, the judge, having had the opportunity to hear testimony from the defendant, completely discredited his claim that any of this information was new to him at the plea. And I think that alone is fairly dispositive. And if the court has no further questions, then I would just rest on my brief.
I see none. Thank you so much. Excellent arguments, both of you. Very, very helpful.
The case is now being recorded.
Good afternoon. Welcome to the Appeals Court. I am Justice Rubin, and I'm joined today by Justices Milkey and Henry. We are hearing oral argument by video conference due to the ongoing pandemic. And the next case we will hear is number 20-115, John Doe, number 524363 versus the Sex Offender Registry Board. I will remind counsel that this is an impounded case and that they should adhere to the impoundment order. Our rules of argument are the same here as they are in our courtroom, which is 15 minutes per side with no rebuttal. And we will hear first from Ms. Green.
Thank you. May it please the court. Good afternoon, Your Honors. Ashley Green representing the appellant in this matter, Doe 524363. The appellant is before you today asking for the court to remand this decision, finding that he must register as a level 3 offender at the highest level. We're asking that it go back to the board for a new hearing in light of this court's holding in Doe 2453, and that the underlying circumstances in this case are directly on point for the type and circumstance that the case law analyzed in Doe 2453, finding that factor 2 must be stricken as it violated my client's due process rights. There is no scientific
the board argues that you waived a factor 2 argument. What do you say to that?
This argument was raised at Superior Court. So this argument has been raised throughout this case up until this point. We did not have the case law that we now have. However, I did cite to Justice Milkey's concurrence in Doe 22188, finding that time in between events is not enough to find that it is both repetitive and compulsive. Since Justice Milkey's concurrence in that case, we now have these 2 other cases. One, a Superior Court case that Justice Wilkins or Judge Wilkins issued the decision. Then both sides agreed it was binding in Doe 2453. In this case, this index offense was a complete anomaly in my client's life. He was just 22 years old. He has never, prior to or subsequently, committed any sex offense. It was over a 3-day period. However, there was no intervening circumstance in the event that would support a finding of factor 2. Therefore, factor 2's application in this case must be stricken. And on further analysis, I submit that the remaining evidence against my client is not enough substantial evidence to support a finding of a level 3 classification by clear and convincing evidence standard. And this was all brought out in my subsequent 16L letter, and the board responded that there was still enough evidence. And I submit that given this isolated episode in my client's life, and the fact that it's the only high risk factor that was applied in this case, there is not enough substantial evidence to continue on and find that this didn't materially affect the outcome of the case. The decision was heavily—
Counsel, we're looking at Judge Wilkins invalidating the regulation, or holding the regulation was invalid, and the board's subsequent decision to live with that and to redo the regulation, which is in the process of doing now. Shouldn't the board get the opportunity to make a decision on whether or not the remaining factors are enough to justify a level 3? By that I mean, isn't the proper method simply a remand to the hearing officer, to the Superior Court, to be remanded to the hearing officer, because it's her decision that matters, not ours or frankly the Superior Court's?
I submit that a new hearing is required and not just a remand for a new decision written. My concern, and I can't believe I'm the only person with this concern, is that the board will find a way to change the language they use, however, still use repetitive conduct as a risk predictor for the future. And the scientific research just simply doesn't support that. And so in this case, if this case were to be remanded for a new hearing, as it should, at least we would have an opportunity to address this issue from the moment of the de novo hearing as a fresh new start, as my client is entitled.
Is their current position, isn't their current position that this case, that factor 2 cannot be used in this case?
The board's current decision, as I understand it, is that
your brother.
factor—
No. We will ask you when it's your turn to argue. I'm sorry, Attorney Green.
And I won't put words in Mr. Doyle or Attorney Doyle's mouth, but it's my understanding that he's saying we're not admitting that factor 2 must be stricken in this case. However, if it is, there is still substantial evidence to support a level 3 finding, period. And that was his rebuttal to my 16L letter. And that's what that said.
And obviously, is your concern when you say that they'll still use repetitive conduct somehow?
Yes.
Notwithstanding, of course, that the statute requires it to be repetitive and compulsive. And notwithstanding the fact that this doesn't seem to count as compulsive under at least Judge Wilkins' decision. Is your concern that they will do that notwithstanding not applying factor 2, or you're concerned that they may try to apply factor 2 anyway?
My concern is that they will not explicitly apply factor 2, however, apply repetitive conduct in the factor that brings in other, I forget the title of it, Attorney Doyle will know, but it's a factor that brings in other useful information, and it will be used in that way.
But isn't exactly the kind of, I mean, we have a fact pattern here of him basically taking a person that he barely knows and then trafficking that person. Isn't that exactly the kind of scenario where we want to warn the public of a danger?
Regardless of whether or not it's compulsive.
Regardless of whether or not it's compulsive, this is a case that there was a drug deal underway, and my client was then convicted of holding the purchaser of the drugs for a number of days and convicted of the trafficking and sexual servitude. However, this was not a stranger that was grabbed off the street. This was somebody that engaged in a relationship, whether it be a drug deal or not, with my client.
Just a single drug deal? Had they met before?
No, this was a single
Okay,
drug deal.
so it is a stranger victim.
That's correct, and that factor
But
was
I also
applied.
have to say, and I'll ask Attorney Doyle about this, really the question is for him. I have no doubt about the danger. I just don't understand where the idea, and I think that this defendant may well reoffend criminally, but they have to reoffend sexually. And I'm not sure I see why there's a high degree of risk of that in the absence of this being compulsive behavior. But I will ask Attorney Doyle. The dangerousness to which Justice Henry refers is obvious. I mean, this terrible, terrible, shocking crime. But we don't disseminate the names of people who commit terrible, shocking crimes unless they are likely to reoffend sexually.
Correct. And the factor 2 application in this case did carry a lot of weight. And I want to repeat, it was the only high risk factor applied in this case. And I think that this court would be hard pressed to find upon review that taking out the only high risk factor still leaves enough substantial evidence that there is a clear and convincing finding that a level 3 classification is warranted for a young man at 22 years old that committed an offense. And if going through the record, he was not the principal agent working on this. There was a 34-year-old that was his co-defendant, for lack of a better term, who was also charged, who was driving the car. My client was a passenger.
He did commit actual rapes on the victim as well as the sexual servitude, and the kidnapping / enslavement. It's not great.
That is correct. And I'm not trying to downplay the offense. I am just stating that the scientific research that must support the regulations does not contemplate the facts of this case in particular in terms of the high risk predicator factor 2. And so I'm happy to go on to my second argument, although I do believe that the argument on its face from the striking factor 2 is enough to remand this case for a new hearing. But my second argument actually plays into my first argument, because after we take out factor 2, we have to look at what we're left with. And unfortunately, in this case, there were 8 factors that were applied without applying or ascribing any weight, whether threshold, moderate, or high degree. And again, upon review, it's very difficult for this court to find that the applications of those factors was sufficient to support the substantial evidence to find a level 3 classification. Had the hearing examiner applied weight, it would be a more meaningful review. But this is an arbitrary decision if there's no weight assigned to these factors, because we just do not know how the factors were applied and how much weight was given to each of them. And so in that, as I stated in my brief, I'm asking for a published decision requiring that the factors that are eligible for weight be given weight. And that way we can have a more meaningful review on appeal of these cases.
Well, I'm not sure under what authority can we say they have to say the weight of each factor? Does it, and even the phrases you used, moderate weight, I don't remember, I've seen people say I give it full mitigating force or full aggravating effect. I rely on this only very slightly. Are those legally meaningful categories?
The reason I use those is there are some factors that already require weight. The hearing examiners don't always use them, but these terminologies that I included are actually taken from the regulations and prior hearing decisions that I have received. So I used the SORB hearing examiner's decisions as the reason for the terminology that I chose. I think
we could say that they have to give a reasoned explanation. And I have to say, and I'll ask your brother about this, I didn't find any reason at all for the 3 here, that is instead of a 2, say. I don't think they know how to reason to the difference between those 2, because I don't think that they do anything exactly. They don't have relativistic data, or if they do, they don't use it. So they never say this person has a 3% chance of recidivism. We think that's low. This person has an 8% chance, medium. This person 15. And if you don't do something like that, it's just gestalt. I mean, I'd almost be inclined to call it arbitrary, although it's been upheld. So I saw no explanation. I mean, yes, I see there's a bunch of factors. How did this person, the hearing officer, decide it's a 3, not a 2? I have no idea. I don't know if they know. It seems almost like a gut feeling or something, or an impression. And I'm not saying that I'm inexpert in this. I'm not saying that your client won't repeat offend or will repeat offend. I have no idea. But I didn't, in reading the thing and knowing that there's 8 factors that go like this and like that, that doesn't explain to me why it's a 3, not a 2. And there was no reasoning in it. But I will ask Attorney Doyle what we're supposed to do about that.
And in this case, and I know you mentioned sending it back to the board and having the hearing examiner give a more reasoned decision, potentially taking out factor 2. Unfortunately, hearing examiner of this case is on some sort of leave that we have not been given any insight into why she's on a leave. So that wouldn't even be an option in this case in particular. But again, maybe Attorney Doyle could give us some insight into whether that's a possibility or not. But if there are no further questions, I would rest on my brief.
Are there no further questions? There seem to be none. Thank you very much. Excellent argument.
Thank you.
We'll hear now from you, Attorney Doyle.
Thank you, Your Honors. May it please the court, again, Thomas Doyle for the board. I would first say that any error of any one factor would not be controlling, I think, in any of these cases. Obviously, factor 2 is a high-risk case, but I believe, based upon the substantial evidence and the application of all the other factors that the examiner relied upon, would support a further level 3 in this case.
It might support a further level 3.
I'm sorry, Your Honor?
It might support a further level 3, but unless it compels a level 3, don't we have to send it back?
If there is no substantial evidence and all of the other...
No. Someone weighed a bunch of things.
Yes.
And concluded it's a level 3.
Yes.
And now the board acknowledges that one of them can't be used. I'm not sure if you acknowledge that, but let's say you do.
Yes.
All right, so factor 2 can't be used. So now we look at it all. Is there substantial? Yeah, there's still all the other stuff. Right. I just don't know what an actual hearing examiner would say if they didn't have the one high risk factor that they found.
Right. Well, I know there's other case law out there that says if part of a decision can be excised and there's still substantial evidence, you can still support the finding of the hearing administrator.
There's always substantial evidence, right? I mean, you could knock 3 of these things out and it'd still be the substantial evidence. It just might not be.
Yes.
Counsel, this is not the first case that has come to this court since Judge Wilkins made his ruling.
I understand.
And as you know, if you understand that, we have sent everyone back. What makes this case different than all of those cases?
Well, I can tell you my argument would be this, Your Honor. As Judge Henry pointed out, this is a pretty specifically bad fact pattern. He kidnapped a stranger woman, plied her with drugs, took pictures of her and posted them on the internet, forced her to have sex not only with him, at least once, if not multiple occasions, but with other men, making him not only a trafficker of a stranger woman, but a rapist, meaning he's a contact offender. And as we know, the SJC has come to the determination that contact offenders are the highest of the risk and the ones they can see the most on the internet because of the nature of the contact. Then you throw in the fact that he has a history of lawlessness and antisocial behavior. And then you add that to the fact of the other high-risk elevating factors that the petitioner found based upon, the hearing examiner found based upon the evidence of this case. It is my position. We have been told that the board is abiding by Judge Wilkins' declaratory judgment that if factor 2 is excised from this, there is enough substantial evidence to support a factor 3. And also, as far as knowing,
counsel, there's enough to support it, but is it compelled?
yes, I would say it is compelled because I think it's easy to get stuck on an individual factor and pick every single one of these decisions apart, factor by factor by factor. When you look at it,
the problem is, from my perspective, this is a terrible crime. Obviously I agree with you. It's a horrific crime. But people murder people, and it's a horrific crime. And we see some pretty terrible crimes. And for whatever reason, the Constitution probably, but for whatever reason, we don't disseminate their names on the internet if they get out of jail and let everyone in the neighborhood know there's a vicious murderer in your midst. Maybe we should, I have no idea. We do it for people, and not just dangerous people. We do it for people who are going to reoffend sexually. I assume that has something to do with our understanding of the compulsion of sexual misconduct. You know, the sort of the archetype example being paraphilias. We think a pedophile is going to offend again and will not be able to control that urge. And we want everyone in the neighborhood to know because this is scary, dangerous stuff. And the paraphilia piece of this is built into factor 2, repetitive and compulsive, can't be controlled. And now we've knocked out repetitive and compulsive. This person remains presumably just as dangerous as they were before, but they have to be dangerous and high risk of reoffense. And without compulsion, how can we know how high the risk is of reoffense?
I see what you're saying, but I would respectfully disagree with your hooking up paraphilia with factor 2. That's actually a paraphilia, as you know, Your Honor, is a mental abnormality, would fall into factor 1, which was not applied in this case.
Inability to control the paraphilia would be part of factor 2. It's compulsive, right? I mean, I think it would, I assume someone with a paraphilia would get factor 2, I would hope, if they'd done something repetitive.
If somebody was diagnosed by a licensed mental health professional with paraphilia being pedophilia or sexual sadism, factor 1 would be applied. Based upon what he did with that mental abnormality, if he went on and, was
repeatedly, because we see those cases, of course.
Obviously now, without the time and opportunity, that threshold inquiry is gone. But if he went on and he was sanctioned by somebody other than the victim, or if he was convicted, then factor 2 would be applicable, as it would be now going forward.
Sure.
Unless and until the board changes its regulations. And then I think it's an unfair comparison saying a murderer isn't posted on the internet. I think the legislative history and studies have shown that sexual recidivism is something that concerns the public and society in general, because it does happen more than once if somebody does it once. And that's what we're doing here, is try to determine if this gentleman is going to recidivate. And what do we use to determine that? We use, as the legislature said, the board's factors. Case law has said in the past that if there is a legitimate and illegitimate part of a decision, if the illegitimate part can be excised and it can be upheld, that's what should be done. And obviously that's what I'm arguing for, based upon the heinous nature of this crime and the application of the factors that are still applicable in this case.
Can you point us to a case where a level 3 classification has been upheld, where there's been one offense over a period of days that had a similar level of heinousness as this case?
Without factor 2?
Right.
Off the top of my head, I cannot, Your Honor. I cannot off the top of my head.
So you seem to be arguing that the hearing examiner does not have to expressly state a particular weight that's being given to a factor. Am I understanding your argument correctly?
That is correct, because at its bare bones, if you look at the board's factors at 1.33, they're already given headings of high risk, risk elevating, additional factors, and risk mitigating factors. I think a lot of the attorneys on the other side get hung up on factor 2, because factor 2, there were 3 ways to apply it. There was threshold inquiry, somebody was sanctioned by somebody other than the victim, or somebody was charged or convicted of another crime. And I think they take that and think that should be with every other factor. But I mean, factor 9 was applied here. He had alcohol or drug abuse. The examiner gave it moderate weight because he wasn't out there drinking and drugging all the time, but there was evidence in the record that he was diagnosed with cannabis and alcohol disorder, and he had D reports for drugs while he was incarcerated. So he didn't get full weight for that. I don't know how you would moderate or show a moderate or high, and you're a stranger victim. You're either a stranger victim or you're extrafamilial victim or you're an intrafamilial victim. I don't know how you codify that. So there is a way to put it. If factor 7, as here is not 7, 9, 10, 11, 12, and a couple of others were applied, it elevates his risk. I'm not quite sure what more is needed other than that.
Yeah, can I ask this? Because this, I don't, you heard me ask your sister, it was more of a comment than a question to her. It's really a question to you. So we see these cases all the time. Sometimes they're level 2 and sometimes they're level 3. And they're all terrible cases. There's no good case coming out of the SORB. It's all terrible. And I look at it, and sometimes the people come in with the level 3 and say they should have been a level 2, and sometimes the level or a level 1, and the level 2 come in and say they should have been a level 1. I look at a decision like the one from the hearing examiner here. I don't see any reasoning that says why it's a 3, not a 2. I'm not saying it shouldn't be a 3. I have no idea. That, like I said before, that's not my area of expertise. But we see these cases, some are 3s, some are 2s, and I can't tell the difference. Sometimes I can. Sometimes I can tell the difference. But a lot of the time, it seems like a judgment call. If the hearing examiner in her expertise had said 2, we'd have said affirm. And if the hearing examiner in her expertise says 3, we affirm. But there's no reasoning. How am I supposed to evaluate the difference between a 2 and a 3 when all she said here are the factors that apply? And she said some of them less than full weight. So maybe you can infer that the others are full weight, or maybe not, maybe yes. How do I know whether it's supposed to be 3 or 2?
Well, the first thing I would say, Your Honor, is by statute, regulation, and by case law, these are all individualized hearings. You can't compare them to somebody else because of the nature of the sex offense, the nature of whether it was
but as a matter of the rule of law, we have to. You can't have arbitrary, my feeling was this guy was going to be a repeat offender. We try to avoid that. We try to have it be based on reasoning.
Right, and that goes, I think, as part of the individualized finding. If the hearing examiner, based upon the facts that he finds at the hearing, decides to come to a 1, 2, or 3, and that analysis is supported by substantial evidence, the underlying facts by preponderance of the evidence, and the overall risk by clear and convincing evidence, obviously this court knows what's quite clear if it's not supported by substantial evidence, error of law or fact. I just think it's a mistake to try to. Obviously, Jed, you said you've had plenty of these cases from SORB. Some of them have been a 2, some of them have been 3, and it's easy to get caught up in that and say, well, this guy had the same fact pattern almost. It's the individualized hearing. That's the only thing I would have to argue in that regard. Now, are you asking, is there need to be more legal analysis?
I don't know if it's legal or sort of psychomedical analysis. I don't know what it is, but we know something about people who offend and reoffend and don't reoffend. The SORB never says to us, the data shows that 8% of people with stranger victims reoffend. this data shows that 6% of whatever intrafamily will reoffend. We think 8% is high. We think 2% is low. We think they're both medium, and 15 is high.
Right.
And I part of me really wishes that you would do that, because there is some data on this, and I don't know. I mean, if the line between moderate risk and high risk isn't a number, then what is it?
Well, obviously, Judge, the reason we do it this way is we're commanded to by the legislature. And I obviously think that the SJC had problems with it too, because they increased our burden of proof to clear and convincing evidence.
Yes, but again, clear and convincing evidence of what and how?
The only thing, I've been there 15 years, and this is the way the state legislatures decided to do it. And with the guidance from the court and the updating of our regulations, we just don't use percentages.
But counsel, I think, I mean, the board typically argues to us that judges, it's not what you think. The primary decision maker here is the hearing officer. Well, in that same vein, if that is true, then doesn't the hearing officer need to make a decision without consideration of the Factor 2 regulation?
Going forward, they do, obviously. Well, the threshold inquiry, the first part of Factor 2, yes. Are you talking about, for a remand?
Yeah.
Well, I'm saying that it doesn't have to get that far. I'm arguing the court could just excise the application of that threshold inquiry and still find a level 3.
On the theory that the evidence is so overwhelming of a level 3 that it would just be a waste of time to remand, is that?
Yes, the application of the rest of the factors based upon the fact pattern of this case, yes. I would just remind the court very quickly that if, as the court has said, that the underlying facts so clearly dictate the appropriate classification, a remand is not necessary. And obviously, you know, it's discretionary on your part.
Of course. All right, I have 11 seconds left. If you got anything good,
I would rest on my brief if there are no other questions, Your Honor. Thank you.
All right. We do have your brief as well as your arguments. You've both made excellent arguments, very helpful to us, and very strong arguments on behalf of your client.